Hey y'all, if there is one thing I cannot stand, it is tossing and turning at night because I'm hot and I'm uncomfortable. But all that ended when I was introduced to Cozy Earth. Crafted from 100% bamboo, these sheets are not only incredibly soft, but also they're breathable, they're moisture wicking, and they keep me cool and comfortable all night long. I literally sink into the bed and feel like I am sleeping on a cloud. They have everything from sheet sets to complete bedding bundles to comforters, everything you're going to need to get a night's sleep. And the brand has been featured on Good Morning America, In Style, Better Homes and Gardens. And guess what? They don't stop with bedding either. They got pajamas for both men and women. And I am telling you, they are the most comfortable pajama sets I have ever worn. They have bath towels, robes, tops, hoodies. If you wear it, sleep on it, or dry off with it, they got it. With free shipping on orders over $50, a 100-night sleep trial, and a 10-year warranty, Cozy Earth will bring you what it brought me: a good night's sleep and a whole lot of comfort. Exposed Podcast has partnered with Cozy Earth to offer my listeners 41% off by using the code EXPOSED at checkout. That's 41% off by going to CozyEarth.com and using the code EXPOSED at checkout. Sleep better, live better, choose Cozy Earth. Sweet dreams await.
We all know that owning a small business means you wear many hats, but sometimes you really need an extra pair of hands. Upwork is how good companies find great and trusted freelance talent. With more than 2 decades of experience, with the simple and ambitious goal of pioneering a better way of working, companies at every stage turn to Upwork to get things done and find more flexibility in staffing key projects and initiatives. They access a global marketplace filled with top talent in IT, web dev, marketing, and more. Posting a job on Upwork is easy. With no cost to join, you can register, browse freelancer profiles, and get help drafting a job post or even book a consultation. From there, you connect with freelancers that get you and can easily hire them and take your business to the next level. Visit Upwork.com right now and post your job for free. That's Upwork.com to post your job for free and connect with top talent ready to help your business grow. That's UPWORK.com, Upwork.com.
Hey everyone, and welcome back to Exposed, Scandalous Files of the Elite. I'm your host, Jim Chapman, and today we are continuing in the Bad Boy series with episode 7 and the continued testimony of Alexander Bradley. Now, the last time that I left you, Bradley got absolutely hammered by the defense on the Boston shooting. And he also got hammered on his statements he made to police where he was questioned about that shooting. Now, in today's testimony, he is questioned by the defense regarding when Aaron shot him. And they focused on the statements he made in his civil deposition. Now, this is the last episode I'm doing regarding Bradley's testimony. He's going to complete that testimony today. So in the next episode, I'm going to cover the verdict in the Boston shootings case as well as the aftermath. And we're going to go ahead and probably in the next 2 or 3 episodes wrap this whole series up. But here's the clips of the finalization, if you will, of Alexander Bradley's testimony.
On the night you got shot on February 13, 2013, it's your testimony that there were 4 of you.
Correct.
Okay, you testified that when you were in the car, you were in the back seat.
Rear passenger, yes.
Rear passenger. There was another guy to your left.
Correct.
Aaron was in the front passenger.
Correct.
And this JP guy was the driver, right?
Correct.
There weren't more individuals with you?
No, sir.
More individuals didn't go with you to Tootsie's?
Not that particular night, no, sir.
Okay. And when you go there, they give you a wristband, right?
Correct. They did that. That night I had a wristband, correct.
To get in that area, you have to, I guess it's like a a special wristband that says next level?
Correct.
So you're going to the next level.
I don't know if that's why, but
You have to go upstairs to the next level, right?
yes, to the second floor.
Okay. May I approach the witness? I'm showing you. Can you move your drink, please? A receipt. Can you read to the ladies and gentlemen of the jury the date?
February 13th,
Okay. And the top of the document says what, sir?
Miami Square Garden 1, Incorporated.
It says Miami Gardens Square 1, right?
Correct.
Okay. And apparently it gives you the item.
Correct.
And what does it say?
Next level, $20. Next level, 20. Says next level, $20 5 times.
Okay. So there's a quantity of 5 different purchases to go to the next level. That's correct?
Correct.
And you mentioned that Aaron was the one buying that night, right?
Yes.
Okay. And in this exhibit 306, you see Aaron's driver's license
Correct.
and his Visa card.
Correct.
And you see the purchase for the next level tickets to go to the VIP room?
I see 5 next level purchases of $20. Correct.
And it's your testimony that only 4 of you were partying that night, not 5.
Correct, it is.
Okay. And in fact, there were more guys there that evening with you, weren't there?
I don't believe that's correct.
More guys and more cars, right?
I don't believe that's correct.
But this receipt says 5, correct?
Correct.
Now, it's your testimony, sir, that after leaving Tootsie's, you left your phone
Correct.
and you got in the car with Aaron and 3 other individuals, right?
Correct.
Okay. And
Actually, Aaron and 2 other individuals.
Aaron and two other individuals, not 3.
Not 3, 2.
Okay, I'm sorry. You're right. 2 other individuals. Okay, so, and you said that you fell asleep.
At a point, yes.
Okay. And and that you have this ability that when a car stops, you wake up.
Yes, I do wake up when cars stop moving.
Okay. Cars rock you to sleep, and when they stop, you wake up.
I don't always go to sleep, but if I do fall asleep in the car, usually when I hit a destination and the car stops, I wake up.
Okay. Do you recall giving a civil deposition in this case?
Yes, I do.
Okay, and that was on January 13, 2016, right?
Correct.
Okay. And do you recall being asked this question, sir? You don't know, though, if the car might have made any other stops right before you were shot, right? And do you recall giving the answer? I can't definitely say no. Do you recall giving that answer?
I don't recall, but if that's what it says, then that's accurate.
Okay. How about this question? Okay, so you don't know if maybe Aaron left the car prior to you being shot, right? And do you recall giving the answer? Prior to me being shot? Question, yes. And you giving the answer, no. I can't say whether he did or didn't.
I don't recall saying that, but if that's what it says, then that's accurate.
Well, let's confirm it so there's no misunderstandings. Page 124, counsel, line 23. Can you read the highlighted portion on line 23 and confirm to the ladies and gentlemen of the jury that you in fact gave that answer?
It says, no, I can't say whether he did or didn't. That's the answer I gave.
Okay. So, in your civil deposition, where your purpose is to sue Aaron, you're trying to get money from him, you can't even say under oath whether he left the car prior to you being shot, correct?
Correct.
But today, you come before this jury after getting your deal and say Aaron Hernandez shot you?
Objection against when you got the deal.
Stay to the form of the question.
You testified under direct examination that Aaron Hernandez shot you.
Correct.
Let's talk a little bit about the shooting, sir. I'm going to show you a series of photographs so we can explain to the ladies and gentlemen of the jury a little bit better of the location where you were shot, okay?
Okay.
Does this look like the alley where you believe you were shot?
Yes, that is the alley.
Okay. Is that a fair and accurate representation of that alley?
Yes.
Okay. Here's another photograph, kind of a little more close up. Is that the alley, sir?
It appears to be, yes.
Okay. And another photograph after that.
Yes, that appears to be the alley.
Okay. I have these marked as an exhibit, John.
No objection.
These being the 3 photographs just identified.
Yes.
All right, why don't we mark them 307 A, B, and C, all being different A and C.
So we can all have a perspective. I just want to go over the general directionality of things, okay?
That's fine.
Okay. This is a warehouse area, correct?
Yes.
There's nothing but warehouses around there.
I know it's an industrial area.
Okay. And when we refer to an alley, you're referring to down here, correct?
Yes, that's an alleyway.
Okay. And it was your testimony under direct examination that this is a fence area here, correct?
Correct, that is a fence.
And that after being shot, you got up from this fence area. Well, you were shot inside the car, right?
Yes, but that view, I've never seen this view. There's another view.
Okay, we'll get into that in a minute.
Okay.
I don't want to...
Because I just can't decipher which end, based on this view.
Okay, we'll go back and forth and you can point that out.
Okay.
So it's your testimony that you're in the car stops, you wake up, and Aaron shoots you, right?
Correct.
Okay, and he shoots you inside the car.
Correct.
Okay, and then Aaron and another guy push you out of the car, right?
Aaron assists another guy in pushing me out the car, correct.
Okay. And the gun used to shoot you was a semi-automatic, right?
Correct.
Okay, that you remember.
I know for a fact.
I'll use those words.
Yes.
You know for a fact.
I know for a fact.
All right. And then when you get pushed out of the car, you fall over here, correct?
I can't confirm that from this view. That's what I was trying to tell you earlier.
Okay. This is the other angle. I'm going to show you another photograph. You see right over here, like these tanks?
Yes.
White tanks?
Yes.
Okay. Show you a picture from another angle. Outward. I guess this is the other view, the opposite view. Do you see that?
Yes.
Okay. You see the crime scene tape back here?
Yes.
Okay. Does that kind of give you a little more general of the direction, or should I show you some more photographs?
If that's where the alley is familiar to me, but I just never saw these angles of these pictures, so I can't really from that angle I can't tell myself exactly where the vehicle was. And I remember there's a fence right next to me. There's a better picture somewhere.
A fence?
There's a better picture with a fence and a cap on the ground.
Okay. That's the fence area, right?
Correct.
You see your hat down here?
Correct.
And you see some blood over here on the piping?
Yes.
Okay. And some blood over here?
Yes.
Okay. Now, you fell down to the ground here, right?
In that area, yes.
Okay. And that's what I guess your blood spattered over to the other side of the fence there, right? If I can zoom in.
I see blood on the other side of the fence, yes.
All right. That's your blood, right? Let me zoom in a little bit more. I'm showing you now 308.
Yes, that's my blood.
Okay. I'm going to show you Exhibit 308B. That's your blood there on the other side of the fence?
Yes.
Okay. So whatever happened, you had enough impact for the blood to go on to the other side of the fence, right? When you hit the ground?
I'm not an expert. You're asking me to answer a question that I can't.
Well, you didn't wipe that out intentionally over there, right? You didn't do anything extra to get the blood on the other side of the fence, right?
No, I just recall grabbing that fence in that fence area to pull myself up.
Okay. Now, your contention. May I approach the witness?
You may.
I'll show you a couple more photos. May I approach? Okay, I'm going to show you a couple more photographs. Does that appear to be an accurate, a fair and accurate representation of your hat in the fence area?
Yes.
Okay. And this second photograph I'm showing you, same thing, but a little bit more out.
Yes.
Okay. A third photo, but again a little bit more out.
Yes.
And a fourth photo, a little bit more of a close-up.
Yes.
Okay. Now, sir, you told the police that you were shot in the car, right?
Correct.
And you told this jury that you were shot in the car, right?
Correct.
But yet, and you had your hat on while you got shot, right?
I don't remember if I had my hat on when I got shot.
But somehow your hat ended up outside in the fence area, right?
Apparently so, yes.
And that is in fact where you were actually shot, right?
No, I was shot inside the vehicle, like I informed you.
Okay. And the police never recovered that vehicle, right?
I wouldn't know, sir. If
They never advised you that they never recovered any vehicle.
No, I was never advised of that.
Okay. And you didn't, when they were pushing you out of the car, you didn't say to them at any time, hey, let me get my hat.
At the time, I just recall my ears ringing. I didn't say anything.
Okay.
To the best of my
So
memory.
you didn't say, hey, let me get my hat. I need to get my hat.
No, I was shot in the head.
Okay. And your hat was on your head, or you don't know?
Again, I'm not sure if my hat was on my head.
Okay. What is this, sir?
That appears to be a shell casing.
Okay. Shell casing to a bullet, right?
Correct.
Okay. And the police recovered that bullet shell casing?
Are you telling me they did?
I'm asking if you know.
I believe so. If there's an evidence marker there, I would say yes. I would guess that they did.
Okay.
Yes, do you know?
No, I don't know definitively that they recovered that.
And do you see that shell casing is outside in the grassy area and not inside a car?
Yes, I do.
And when a semi-automatic fires a gun, we went over your knowledge of guns yesterday. When a semi-automatic fires a gun, shell casing comes out of the gun, correct?
That is correct.
And in this case, it ended up outside in the grassy area near your hat, right?
Yes, I don't see my hat, but yes, I see the shell casing. If my hat's right by there, correct.
Okay. You wouldn't argue with that though, right?
No, I wouldn't argue if my hat's right by there, the shell casing's by my hat.
Okay. Okay, I'm showing you Exhibit 309B, which is the shell casing. Do you see that is marked, given the evidence marker number 1?
Yes.
Okay. And this is a far out shot, which is Exhibit 309A. Do you see your hat there?
Yes, that appears to be
Next
my
to a
hat.
marker that says number 1.
Yes, that appears to be my hat.
Okay. So would you agree that evidence marker number 1 is next to your hat?
Yes.
Okay. Now, this is an area, I want to kind of give you I want to go over the alleyway again. This is an area and then show you 307A. Would you now agree, sir, that the area in question that we're talking about is this area right here near the fence?
Yes.
Okay. And when you say you walked down the alley after getting up, you got up here and you walked down this alley, correct?
I believe so.
Okay. You walked all the way to the end of the alley, right?
Yes.
Okay. Then you came back, right? You walked all the way back here.
I just recall walking to the end of the alley. I don't recall like doing it back and forth or something like that.
When you walked down this area, sir, did you hide your gun?
Objection.
No, you may answer that.
Sir, I didn't have a gun.
Okay. So there's no gun for you to hide over there, right?
Absolutely not.
Okay, sir. So, after walking down this area, do you recall walking back?
I just recall walking to the end of the alley to get help.
I'm going to show you another photograph that might help you out. Do you see this bloodied area over here?
Yes.
Okay. There's no alleyway between that this area, this fence area, and here, correct?
Correct.
And the alley would be this way, right?
Correct.
So, is it fair to say, sir, that you walked down this alley, over there, and then walked back, and ultimately collapsed over here?
It's possible.
Okay. I'm going to show you another close-up shot. And I'm showing, for the record, Exhibit 310E. Is that blood, sir?
It appears to be.
You believe that's your blood? On the pavement?
I'm not sure, but I mean, it could be.
Okay. Anybody else bleeding out there that day?
I wouldn't know, but I know I was bleeding a lot out there that day.
Okay, and that's your blood, right? I'll strike the court. If you don't know, do you know?
I'm not sure if that's my blood, no.
Okay. Now, sir, after being shot in Florida, you did not cooperate with the police.
Correct. Correct.
And that's because you didn't know who shot you.
That is incorrect.
Okay. That's incorrect, right?
Right.
You knew who shot you.
Most certainly.
And you knew the details of who shot you and how.
Extensively.
Okay. And you refused to cooperate with the police, right?
Correct again.
You then began to, bless you, you then consulted with a lawyer.
Yes, at some point.
Okay, and then you sent all those text messages that we went over, right?
At some point, yes.
Okay, and your intent was to get money from Aaron Hernandez.
At a point that became my intent, yes.
Okay, we know you wanted to kill him too, right?
Yes.
Because you're a killer.
Objection.
Sustained.
Now, sir, after wanting to kill him and take his money, or sue him for money, you also sued CNN, right?
Objection.
I'll see you at sidebar. Objection, it is sustained. You're to disregard the question.
Now, sir, you didn't cooperate with the police, right?
Correct.
And then later on, the Florida police, after you cut your deal, came and tried to speak with you again, right?
Objection.
Sustained as to the form of the question.
Okay. October 8th, 2013, you had your proffer with Mr. Hagan.
Correct.
Okay. You got immunity on the 18th of October 2013.
Correct.
And then the Florida police came calling, right? They came to see you?
Not correct. Not after the, no.
Okay. They continued to see you in Massachusetts, right? They came up here?
Yes, but long before that proffer agreement and immunity, way before that.
Okay. And then subsequent to that, right?
Subsequent to me being shot in Florida?
No, subsequent to you having your deal, your immunity deal.
No, you got the time frames wrong, so it wouldn't be subsequently. Prior to me receiving immunity, they came.
And you refused to cooperate with them then?
That is correct.
And you had already sued Aaron Hernandez?
I believe so.
Okay, so you were already making it public that he shot you, right?
Yeah, it went public at some point.
Okay, lawsuit's a public record, right?
Yes, it is.
Okay, and the police knew that you were claiming Aaron was the shooter, right?
Correct.
Okay, but you still did not want to cooperate with the police, right?
I still didn't cooperate with the police.
Still to this day, you have not cooperated with the Florida police.
Correct.
And that's because you know that those who you were dealing drugs with in Florida will kill you
Objection.
if you were to testify or give any information about your drug dealings in Florida. Isn't that right, sir?
Sustained as to the form of the question.
And that's because of your fear of retaliation from those in Florida, right?
No, you may answer that.
Absolutely not the case. I have no fear of retaliation.
You testified that the reason you didn't cooperate was because you don't snitch.
Because I didn't want to handle that matter with Mr. Hernandez that way.
And because you don't snitch. You recall Mr. Hagan asking you about your code?
No, refresh my memory, please.
Mr. Hagan asked you that that's not what you do because that's not your code, right?
I don't recall him saying those exact words. I believe telling Mr. Hagan that's not how I wanted to go about dealing with the situation.
It's your contention, though, sir, that you don't snitch, right?
Judge asked an answer.
No, you may answer that question.
Yes, it's my contention that I do not believe in snitching.
Well, what are you doing right now?
Objection. Sustained.
All right. You talk about in all your text messages about not being a snitch and not being a rat, right?
Correct.
Okay. And you went through this whole thing with Mr. Hagan about snitching and ratting and all of that, right?
I went through the text. I believe you're correct.
Okay. And you would agree that snitching and ratting is dangerous business in the drug dealing trade, right?
Judge.
No, you may answer if you have a view on that.
I believe it can be.
Okay. It could be very dangerous if you're talking to the police. Other drug dealers may want to come and kill you, right?
It's possible.
You testified a moment ago to the ladies and gentlemen of the jury about knowing who shot you, right?
Correct.
And all of the details about who shot you and how, right?
Correct.
Okay. You recall giving we've testified about a lot of text messages and things like that from your phone that was extracted, right?
Correct.
Okay. And do you remember, I'm referring to Exhibit BBBB, sending this text. Now you're sure once I withdraw this lawsuit that I won't be held on perjury after I tell the court the truth about me not recalling anything about who shot me.
Let's see what's up there.
Hey, sir. Do you recall turning over your phone to the police?
Yes.
Okay. And do you recall signing this consent to seize and search?
Yes.
You remember Mr. Hagan during his direct questioned you about it? About how you were kind enough to waive your rights on this phone?
Yes.
Okay. And this is your signature?
Correct.
And this is the signature of your lawyer, right?
Yes.
Okay. And the name of your lawyer is Mr. Pickering, right?
Correct.
Okay. Robert Pickering?
Correct.
And you call him Pick?
Correct.
Okay. This text message is to what number, sir?
860-922-5297.
Sorry. And the name underneath it says?
Pick.
Pick. And that's how you refer to your lawyer.
Yes.
Okay. And you had a communication with your lawyer asking him for legal advice, right?
Correct.
And you know that when you speak to your lawyer, everything is confidential.
Correct.
Unless you waive it like you did here.
Correct.
Okay. You also deleted this message, did you not?
I don't know if I deleted it.
Okay. Do you recall deleting this message?
No, I don't recall deleting it. I wouldn't have. There's no reason to.
Okay. So it's your testimony that you would not have deleted this message that says, now you're sure, well, look, now you're sure once I withdraw this lawsuit, that won't be held on perjury after I tell the court the truth about me not recalling anything. You see the word anything in there, sir?
Correct.
About who shot me. Do you remember that?
Yes, I remember that text.
Okay. Mr. Bradley, I want to tie up a couple of things before we conclude. First of all, do you remember the questions that we referenced in regards to Jamar Durham?
Yes.
Okay. I'm going to show you a police report. I'd like for you to review it and see if this refreshes your recollection as to Mr. Durham. Okay?
Okay.
Sir, you testified to the jury that after the shooting on July 16, 2012, that you never used the Toyota 4Runner again. Do you recall that testimony?
Yes, I believe I do.
Okay. And do you recall giving a statement in your proffer, one where you got the deal? When asked, did you ever, page 97, Counsel, line 13, did you ever see the car again after that night? And do you recall giving the answer? Yeah, to be honest, I may have even driven it after, because what's throwing me off is the fact that I know that they came to the stadium and asked for the car. At some point, it must have been, back out. And I think that's when he dropped it off over there and put it in the garage. I mean, I wasn't with him, but when he did it, that's what would have happened. That's where it was. Do you recall giving that statement, that answer, sir?
No, I don't recall, but if that's what it says, then that's what I said.
Okay. And this, again, is a situation where your memory does not get better with time, right?
Objection.
Overruled. You may answer that, P.T.
I guess in this instance, that would be correct.
Okay. Now, I'd like to mark the text that we referred to before lunch as an exhibit, Your Honor.
Are you offering that as an exhibit?
Yes, sir.
Is there an objection?
Subject to redactions, Your Honor.
We have an agreement to just...
All right. If there's an agreement as to redaction, then it is received, subject to that redaction.
Okay, sir, Mr. Bradley, you recall this text message that we reviewed before we went to lunch?
Yes, I do.
Okay. And this was a text message sent to your lawyer?
Correct.
Okay. And in this text message, you state the following. Now, you're sure once I withdraw this lawsuit that I won't be held on perjury after I tell the court the truth about me not recalling anything about who shot me? My question to you, sir, is do you see the date that it is sent?
Yes.
Okay, and that's July 5th, 2013 at 12:28 in the afternoon?
Correct.
Okay. Now, do you recall I'm now showing Exhibit 301, which is your deal with the Commonwealth.
Yes, I do.
Okay, remember when we first began talking, I went over this line by line with you.
Yes.
Okay, and do you remember the section where it says, if the district attorney learns that the information or testimony that Mr. Bradley provides after the date of this letter is not complete and truthful, then the district attorney may declare this agreement null and void. Should the district attorney declare this agreement null and void because the information or testimony provided by Mr. Bradley is not complete and truthful, the district attorney may institute a prosecution of perjury. Do you see that, sir?
Yes, I do.
Okay, and you understand all of that, right?
Yes, I do.
Okay, now, you sent that text message July of 2013. You recall that?
Correct.
You signed this document on September 10th, 2014.
Correct.
Okay, and in between September 10th, 2014 until now, has the district attorney informed you that they have decided to declare your agreement null and void?
No, they haven't.
Okay. Did you get any bad news at lunch?
No, I did not.
Okay. Aside from the bologna sandwich, nothing negative happened.
Objection.
Sustained.
If I can have just a moment, Judge. I have no further questions.
Mr. Hagan.
Good afternoon, Mr. Bradley.
Good afternoon, Mr. Egan.
Just want to clarify some of the questions that were asked on cross-examination. Let's start with what Mr. Baez just left off with, the text message between you and your lawyer sent on July 5th, 2013. I'm just going to place a portion of that on the screen. I believe it's now Exhibit 311, subject to redaction. In addition to that text, Mr. Bradley, is there also a text above that relative to a grand jury proceeding? Can you just read that text?
And last but not least, my license are suspended. I need an eye procedure, and me being scared for my life isn't enough for me to get out of testifying to the grand jury.
Mr. Bradley, at the time that you sent that text, July 5th, 2013, were you summoned to appear? Did you have notice that you were due to appear in a county grand jury other than Suffolk County?
Yes.
And was it your understanding that you were going to be asked questions related to the shooting of you on February 13th, 2013 in that grand jury?
Yes.
And when you sent the text message regarding your question to your lawyer about whether withdrawal of the lawsuit would somehow cause you to be held on perjury, what did you mean by that?
Prior to that grand jury summons, I had filed a civil matter against Mr. Hernandez. As I previously stated to the court, my whole objection was to try to figure out how to move forward with civil litigations, but not get him charged criminally. So being that I had a sworn document already, a civil one that he shot me, I was trying to figure out how I could go to the grand jury and not have to tell him that he shot me, because I didn't want him charged criminally. I wanted to sue him and deal with it a different way.
But were you under the understanding that having him charged criminally would in some way affect your settlement on the lawsuit?
Yes, and then in addition to that...
Objection, Judge, for the comment about the settlement.
All right, ladies and gentlemen, you may consider that only insofar as it relates to Mr. Bradley's state of mind. That is, what he was thinking or concerned about. References to any lawsuit or settlement of a lawsuit are not relevant in any way to the issues in this case, and you're not to draw any conclusions or inferences from the fact that there was a reference to some resolution of that lawsuit, nor are you to speculate at all as to what that resolution might have been. It is not relevant to this case, and it is not evidence from which you may draw any inferences in this case. Mr. Hagan put a question.
Just regarding your state of mind, Mr. Bradley.
Objection, Judge. This has been asked and answered.
Didn't finish it.
Let's hear the question.
Just regarding your state of mind, Mr. Bradley, other than not wanting him to be charged criminally, did you have any other concerns regarding testifying honestly in a grand jury?
Objection, Judge. This has been asked and answered.
Overruled.
Now, my issue was I would, in essence, perjure myself if I filed a civil settlement or matter saying that Mr. Hernandez shot me and then went to the grand jury and told them I don't know who shot me, which is what I was torn between because I didn't want him charged criminally, but I wanted my civil matter resolved. So that would have constituted perjury if I said one thing and if one sworn document and said something in another.
And did you at some point even contemplate or intend to lie in the Bristol County grand jury and say you did have a shot?
Sustained. Jury will disregard that question.
And just to clarify, Mr. Bradley, on Exhibit 311, within, correct me if I'm wrong and I'm reading this correctly, the text about your concern about perjury, giving two inconsistent statements as you've described, was that sent on 7/5/2013 at 12:38 a.m.?
Yes, it was.
And your question about trying to get out of testifying in the grand jury, how much longer was that? How much later after that was that sent?
It appears to say 12:40, 2 minutes.
And Mr. Bradley, you asked a number of questions about the phone and your consent to search the phone, correct? You recall those questions?
Correct.
And in fact, Mr. Baez showed you, I'm not sure if this has been entered yet, Your Honor, but if not, I would ask that the consent form be entered as the next number exhibit.
I believe that form's been answered previously.
We thought we'd receive that as an exhibit.
We have no objections.
David, where are the recent exhibits?
Do you recall it?
All right. Apparently it was shown but not received as an exhibit. We will receive that.
Would you please call?
Mr. Bradley, just to clarify time frame, I'm placing on the screen what's been entered as exhibit number 312. That's the consent to search that was shown and referenced by Mr. Baez during cross-examination, right?
Correct.
And the date that this is signed is in September of 2014, is that right?
That is correct.
And in this document, you agree to relinquish full custody and control of the item and its contents. Tell me if I'm reading this correctly. I also acknowledge that I'm voluntarily relinquishing any expectation of privacy in cellular phone and its contents. You basically give the Boston police the permission above to conduct a full forensic search of the phone as well. Is that correct?
That's correct.
And recover and download any and all digital data and files contained therein.
That is correct.
And Mr. Bradley, are you aware of how this phone was found and how it was that you came to give that consent? How and when it was found?
I can't remember the exact date, but I know it was recovered by my daughter's mother.
And seeing the date on the form of September 10th, 2014, do you believe it was found around that date?
Yes, it was close to that date.
And once that phone was recovered, what was your state of mind about the recovery of the phone?
Objection, Judge Welcome.
Sustained.
Well, did you have any communications with your child's mother, Brooke Wilcox, regarding what you wanted done with that phone?
Objection, Judge.
Sustained.
Mr. Bradley, what did you want done with the phone when you found it?
Well, when the phone was found, I didn't have a problem with her turning it over.
Did you want her to turn it over to the police?
Section Judge, legal.
No, you may answer that yes or no.
Yes.
And in fact, on jail calls at around that time, do you recall whether or not you were excited or not excited when she told you she found the phone?
Objection, Judge.
Sustained.
Did
Move to strike.
The jury will disregard that question.
shortly after the police, well, strike that. Shortly after Miss Wilcox advised you that she found the phone, did Boston Police Homicide Detectives come speak to you?
Yes.
And did they have you sign the consent form that's been entered as Exhibit 312?
Yes.
And prior to signing that consent form, did the detectives threaten you, coerce you, or do anything to cause you to execute that waiver?
No.
Did you voluntarily relinquish all rights to that cell phone and allow the police to download every single piece of data on it?
Yes, I did.
Did you provide any restrictions of things you wouldn't let them download, didn't want them to download?
None whatsoever.
And in fact, Mr. Bradley, did you also, yes or no, assist the police in determining what the passcode was for that phone, if you remember?
I believe I tried to assist, yes.
And when you did that, Mr. Bradley, did you know that some communications between you and your attorney, Mr. Pickering, were included on the cell phone?
Yes, I did.
And just by way of timing, Mr. Bradley, because I believe Mr. Baez asked you a number of questions on cross-examination about timing, this was in September of 2014, correct?
Correct.
And when was it that you entered into your agreement, if you remember?
Sometime in 2013.
October 8th, 2013, does that sound correct?
October 18th, I believe. Yes, correct.
And Mr. Baez asked you a number of questions about the text messages where you recall the text message questions that Mr. Baez asked you, correct?
Correct.
And I believe he asked you questions about the text messages where you referred to certain weaponry, certain types of guns, and those things. You recall those questions Mr. Baez asked you?
Yes.
And then Mr. Baez also asked you whether or not your deal was deemed void after the Commonwealth received those text messages. You recall that?
Yes, I do.
And in fact, is it fair to state that those text messages were not even uncovered until after September 2014, when you turned over your phone voluntarily?
That is correct.
And did you turn over your phone voluntarily knowing that you had the text messages between you and Mr. Hernandez?
Yes, I did.
Now, just a few questions, Mr. Bradley, about your cooperation agreement that was referenced repeatedly by Mr. Baez. First, regarding the timing of it, I believe Mr. Baez asked you questions about the proffer on October 8th, 2013. Do you recall those questions? Or do you recall being asked about that?
Yes, I do.
And I believe you testified that that was when you signed the agreement and then gave a tape recorded statement. Is that correct?
Yes, I gave a tape recorded statement on the 8th. Is that right? I believe that's correct.
But on the 8th, after you gave your statement, did you have as Mr. Baez kept referring to it, did you have a deal yet?
No.
Is it fair to state that you didn't have a deal?
I object to the leading. I've let it go on for a little bit, but
Please don't lead the witness.
When was it that you ultimately had the deal, so to speak?
On the 18th.
10 days later.
Correct.
Now, Mr. Baez asked a number of questions about the portion of exhibit number 301, specifically paragraph number 2, talking about the satisfaction of the district attorney that Mr. Bradley was not the individual who fired the weapon, and that upon satisfaction of the district attorney, that the Commonwealth agreed to apply for judicial immunity prior to you testifying before the grand jury. Is that correct?
That's correct.
Now, as far as the satisfaction of the district attorney, Mr. Bradley, is it fair to state, or what is your knowledge as to when the district attorney was satisfied allowing you to testify before the grand jury and be given immunity? What date?
On the 18th.
So 10 days later.
10 days after I came in proffer.
And just to clarify on judicial immunity, Mr. Bradley, Mr. Baez asked a number of questions suggesting to you that at any point if the Commonwealth or if the district attorney was dissatisfied with your answers or felt that you were not truthful, that your immunity could be revoked. Do you recall those questions?
Repeat that, please.
Do you recall Mr. Baez suggesting that your deal of having judicial immunity could in some way be pulled back by the district attorney if the district attorney felt you were not being honest and truthful. You recall those questions?
Yes, I do.
Even if you took the witness stand and testified under oath that somebody other than the defendant, Aaron Hernandez, shot and killed Daniel Diabrera and Safira Furtado, could you be prosecuted for murder?
Absolutely.
You think you could?
Repeat it. If I took the stand and prosecuted that someone else other than Mr. Hernandez
Yes.
committed the murder?
Well, let me ask you another question, Mr. Bradley. What is your understanding of immunity? Is it once you're given it, you have it for the duration, or do you think it's conditional?
My understanding is that you have it unless you lie.
So unless you lie, then you could be prosecuted for what?
For perjury.
But that's it, perjury, correct?
Correct.
And as in your state of mind, and also, again, His Honor's instructions, just calling your attention to Mr. Baez's questions, I believe yesterday, or perhaps this morning, about the fact that you admitted to getting the gun, and whether or not you were prosecuted for that, or whether or not the Commonwealth pulled its agreement. You recall those questions, Mr. Baez?
Yes, I do.
But were you compelled to testify about that in the grand jury pursuant to your immunity agreement? Did you testify about that?
Yes, I did.
So, Mr. Bradley, what is your understanding as to you having to satisfy the prosecution in order to get the benefit of immunity?
It's my understanding that it's not my job to satisfy anyone. It's my job to just state the facts.
So we're going to move on to some of the factual questions that Mr. Baez had asked you. He most recently asked you about the Forerunner and when the last time was that you saw it. What's your best memory as to, in relation to the early morning hours of July 16, 2012, when the last time you saw that Forerunner was?
My last memory of that Forerunner was Miss Singleton taking the Forerunner from the residence on 47 Newberry Street, and that was it.
And just to clarify, timing-wise, was it after that point that you had a conversation with the defendant that you previously testified to regarding what he had asked Tanya to do with the car? Was it after that?
No, the car was removed prior to me having a conversation with him about that.
Right. So the car was removed, and then you subsequently had a conversation with him about her doing something to the car.
Correct.
And what was that he asked her to do with the car? I told you he asked her to do with the car?
He wanted her to clean it and then hide it.
And then Mr. Baez asked you, or he actually read a portion of a transcript where you referenced the stadium incident with the car. And just to clarify for the jurors, what incident was that, and what's your recollection as to when that conversation took place?
I don't remember exactly, but I recall Mr. Hernandez saying that someone came to get the car. I believe it was the car dealer, and that he told him to leave, that he was upstairs. I guess they called him and told him they were downstairs to get the truck, and he told him to leave. And
did he tell you why he did that?
He didn't want them to have the car.
Did he think they were somebody?
Yes, he thought it was the police.
So was this conversation...
Objection, Judge, also speculation. This right.
All right, for a question.
Did he tell you what he thought, who he thought they were?
Yes.
Who did he say he thought they were?
He told me he thought it was police coming to get the car.
And this conversation, was this after July 16, 2012?
I believe it may have been, yes.
Now, you're asked a number of questions by Mr. Baez where he showed you certain travel documents, and I believe the heading on the top was Lux Travel. You remember those questions and seeing those documents?
Yes, I do.
And I believe, Mr. Bradley, correct me if you're wrong, but you did authenticate, yes, that's your name on the travel documents, correct?
Yes, I did.
Did you make those travel arrangements?
No.
Were those tickets you purchased?
No, Mr. Hernandez called me and told me to give him my first name and my information so his flight lady could book the flights for us.
And his flight lady, do you know what company they booked flights through?
No, I don't.
But Lux Travel, is that a travel agency you've ever used, personally?
No, I never heard of him till today.
Now, you're asked a number of questions by Mr. Baez about the phones that you had, your phone records, and the fact that you had two phones. You recall those questions?
Yes, I do.
And I believe in response to one of Mr. Baez's questions, you said, I can tell you who had my phone and what the circumstances were. in or around February 13th, 2013. Do you recall giving that answer?
Yes, I do.
Explain what you meant.
The 726 number that he was indicated, well, 860726 number, was in Connecticut at the time.
Who had it?
I had left it with a friend of mine so he could proceed with my business while I was in Florida.
And the phone calls, purportedly, at least from what Mr. Baez showed you from the exhibit, I believe it was perhaps 294, the phone calls to Mr. Hernandez's phone on February 13th, 2013, do you know what the nature of those calls were?
Yes, that was from my friend who had my phone in Connecticut.
And those phone calls, did those happen after you were shot? Or around the time you were shot?
Yes, I believe so.
And did you make those phone calls?
Absolutely not.
So when Mr. Baez asked you repeatedly if you had two phones in Florida, did you have two or did you have one in Florida?
At no point did I have two phones in Florida.
So the 860, and what was the other prefix?
I believe it had to be either 9. Oh, you mean
Which one was the one up in Connecticut?
860726. I can't remember the other 4 digits.
The one that had 726 was the one in Connecticut?
Correct.
And I believe you were also asked some questions by Mr. Baez regarding your phone itself and whether or not it was lost. Do you know what happened to your phone in particular at Tootsie's?
No.
Do you know for a fact that you left it behind, or do you know whether or not somebody may have taken it?
I know for a fact that I left it behind, and I don't know after that point what happened.
Did anybody ever return the phone to you?
No, sir.
Now, Mr. Bradley, we're also asked some questions by Mr. Baez regarding your testimony. I believe it was in your October 8th, 2013 statement regarding the car ride from Massachusetts to Connecticut taking about 2.5 hours. You recall those questions?
Yes, I do.
I believe Mr. Baez read you a portion of your answer where he read back to you that you thought...
Object to this new testimony.
What the question is.
What is your recollection of what you told detectives as far as how long the car ride took?
I don't recall exactly how long I said the car ride took.
And did you ever describe to detectives in October of 2013 whether or not you had gotten lost?
Yes, I said that. I believe we may have gotten lost along the way.
In addition to getting lost, Mr. Bradley, did you also indicate to detectives at or around the same time describing how long it took as to whether or not you were always...
To the leading. Rephrase.
Did you all, in addition to getting lost, did you also describe whether or not you were planning to go somewhere else other than Connecticut?
Continues to lead.
Now overruled.
Go ahead, sir. You can answer.
Yes, I indicated at one point I believe we were going to go to Plainville originally, which was his old residence.
Based upon the initial intention to go to Plainville, Mr. Bradley, did that change your route at all back to Connecticut?
Yes, that would have rerouted us.
Would you have gotten on different highways to go to Plainville? For those who may not know where Plainville is.
Yes.
Mr. Bradley, we're also asked a number of questions on cross-examination by Mr. Baez regarding whether you heard 6 shots or 5 shots. Do you recall those series of questions?
Yes, I do.
And I believe you indicated on cross-examination that when you testified before the grand jury, you said how many shots in the grand jury?
I recall saying 5 shots.
And I believe Mr. Baez called your attention to your initial statement on October 8th, 2013, where he read a portion to you that said about 6 shots or something to that effect. You recall that line?
Objection, Judge. That's not what the transcript reads.
Put the question.
What is your recollection as to what you said on October 8th?
Objection, Judge. I would ask that you use the actual transcript instead of trying to minimize it.
The witness may answer that question.
I don't know if it was exactly on the 8th, but I know at one point I said 5 or 6 shots.
And what, if any, confusion was there for you as to 5 or 6 shots?
Objection, Judge. Overruled. Question about the statement. I would ask that he use the actual transcript instead of
Repeat the question, please, Mr. Hagan.
reading the false testimony with your
Overruled.
What, if any, confusion was there between 5 or 6 shots initially for you, sir?
Well, I would guess that I just know that type of gun holds 6 shots. So,
Did you hear any noises after the shots were fired?
yes, I heard clicking noises.
And just based upon if you know, what noise does a gun make when it's empty, a revolver, and you continue to pull the trigger?
It makes a clicking noise when the gun's empty, when the chamber's empty.
But ultimately, Mr. Bradley, you've already testified to this. You testified in the grand jury to hearing 5 shots, correct?
Correct.
Did anybody prior to you testifying in the grand jury, whether it be police or prosecutors or anybody, suggest any significance whatsoever to 5 shots versus 6 shots?
No, sir.
Was there any conversation at all regarding 5 shots versus 6 shots from prosecutors or detectives prior to you going to the grand jury?
No, sir.
In your mind, was there any significance whatsoever to 5 shots or 6 shots before testifying in the grand jury? In your mind?
Well,
objection.
Well, I mean, let me rephrase the question.
Rephrase.
I think it was a little confusing when I answered it. Did you think that it was more important for the case to say 5 shots rather than 6 shots when you testified in the grand jury?
Objection to Judge. Possible speculation.
I'll see you at cyber.
In October of 2013 to there being 5 shots fired from the gun. In your mind, was there any significance to there being 5 rather than 6 shots?
Objection.
Your mind.
no.
And had anybody told you that there was any significance to that?
Asked and answered.
Sustained. I think that's recovered.
Now, Mr. Bradley, I just want to clarify a couple points regarding your shooting in Florida. Actually, while that's being looked for, Mr. Bradley, let me ask you some other questions. On cross-examination, you were shown what's now been entered as Exhibit 302. Is that correct, sir?
That is correct.
And you were also asked questions about whether or not you observed Mr. Hernandez ever have this picture taken. You recall that?
Yes, I do.
And I believe your answer at one point to one of Mr. Baez's questions on cross-examination was, I wasn't babysitting him. Did I write that down correctly?
That's accurate.
And calling your attention now to the very beginning of the night when, as you described to Mr. Baez in cross-examination, you went to the left side of the bar, he went to the right. Was there a period of time that you lost sight of Mr. Hernandez?
Yes, there was some period of time.
Sustained.
Did you,
Move to strike.
No. Let's wrap it up.
Mr. Bradley, was there ever a point during the night when you first went into club where you lost sight of Mr. Hernandez?
Objection, Judge. Asked and answered.
Overruled.
Yes,
When was that?
when we first came down into the bar.
Do you know about how long it was that you lost sight of?
I can't exact it. No, not exactly.
And in fact, Mr. Bradley, at some point, did I show this photograph to you some time ago?
I believe you may have.
Objection, Judge.
Sustained.
May we approach?
No, there's no need. Is there anything further?
Yes. When you were showing this photograph, Mr. Bradley, did you identify this as a photograph taken on July 16, 2012?
Objection.
See you at sidebar.
Mr. Bradley, you were asked a number of questions on cross-examination about the Florida shooting. You recall being asked a number of questions?
Yes,
And I just have on the screen what's been entered as exhibit number 310, showing the parking lot area. Do you recognize this as the area where you were, after you were shot, you were pushed out of the car in this area?
Yes.
Can you just clarify for the ladies and gentlemen of the jury your best memory of when you were pushed out of the car, where you landed and where you went from there?
Well, I was pushed out of the car in the alley. I was still further down.
So you were further down in the alley?
Yes. I believe I remember that alley.
So placing on the screen what's been entered as Exhibit 307. Does that alley look familiar?
Yes.
So you believe you were pushed out there, sir?
Yes, right over in this area to where I rolled right to the fence. So the fence was like, I kind of rolled.
Can you using, that's a touch screen in front of you, Mr. Bradley, can you, using the touch screen, show what your best recollection is of where you were pushed out and where you rolled?
I believe, I know I was in this area, but I just remember making a roll to a fence, like rolled over and used the fence to pull myself up.
And when you rolled over to use the fence to pull yourself up, placing Exhibit 309 on the screen, is that the area where you rolled over to pull yourself up on the fence?
Yes.
Now, regarding the blood-stained area that was shown to you in photographs by Mr. Baez, I have on the screen 310, you indicated you weren't sure necessarily if it was your blood, but do you recall ever being in this area after you were shot?
I know I was when the ambulance pulled up, I was at the end of felt like a parking lot or a roadway, like some type of alley. I just remembered it being stumbling to where some pavement was and the ambulance picking me up from there.
And do you recall whether or not you did go back and forth in the alleyway, as Mr. Baez asked you?
No, I don't recall ever going back and forth in that.
Now, you're asking questions by Mr. Baez regarding the jail calls. You recall those questions and the fact that you were on recording indicating that you didn't know anything about the incident. You recall those calls?
Yes, I do.
Those questions?
Yes.
And why was it that you stated you didn't know anything about the incident on the calls?
Objection, Justice, was covered in the rec.
Now, you asked a number of questions by Mr. Baez about City Angels. And I believe at one point in response to Mr. Baez's question, you said that you wanted to explain. What did you mean by the fact that Mr. Hernandez had some type of issue with people who wore City of Angels clothing?
The specific group of gentlemen who he felt he was in conflict with or that were staring at him the majority of them had on City Angels attire. Just the clothes they were wearing.
And to your knowledge, Mr. Bradley, is City Angels, is that a clothing line, an attire?
Yes.
And is that available to buy publicly by anybody?
Yes.
And are you suggesting that anyone who wears City Angels clothing is associated with some group that had a problem with Mr. Hernandez? Are you suggesting that?
No, all people that wear City Angels don't have a problem with Mr. Hernandez. The particular group in conflict has City Angels.
Mr. Bradley, you asked a number of questions on cross-examination about seeing the people you thought were at Club Cure at Club Capri across the street shortly after. You recall those questions?
Yes, I do.
And I believe in one response to Mr. Baez's questions, you said, I believe it was them. They looked similar to the group. Do you recall saying that?
Yeah, I recall saying.
I want to cover some of the testimony that you talked about yesterday. You mentioned in a redirect that when Tanya came to Brooks' house, you saw Aaron and Tanya engaging in a conversation.
Correct.
And she came in the house.
I believe she may have stepped in the house, just into the house. Correct.
Okay. And you heard Aaron say some things to her?
I didn't hear exactly what he was saying to her, but I heard some conversation.
And you saw the conversation with your very own eyes, right?
I started to walk off as they were talking, but I saw the beginning of the interaction, yes.
Okay. Do you recall, we've gone over this a lot, your October 8th proffer? You remember that? October 8th, 2013?
Are you asking me if I remember proffering on that date? Yes, I do.
Okay. And do you remember during this proffer you swore to tell the truth?
Yes, I do.
The whole truth? So, but you wanted to be truthful to the police, right?
Yes.
In fact, this was after you signed your letter promising to Mr. Hagan that you're going to tell the truth. Right?
I believe so.
The whole truth. Remember, complete and accurate? Cover that?
Yes.
Okay. And nothing but the truth.
Yes.
Okay. And do you remember on page 75, counsel, being asked by the police, did you see Tanya that day? And then giving the answer, no, I did not see her.
No, I don't recall giving that answer.
Okay. May I approach the witness?
You may.
Does that refresh your recollection, sir?
Yes.
Okay. Those are your words, aren't they, sir?
Yes.
The words that you just spoke moments ago to the jury are different than these words, right?
Correct.
Okay. Now, I'm gonna need that again. You talked yesterday about 5 shots, right?
Correct.
Okay. And you said to this jury yesterday that you told the police on October 8th 5 or 6 shots. You recall making that statement?
At a point, I recall making that statement. I don't know if it was on the 8th, but I recall making that statement.
No, we're talking about specifically the 8th, because Mr. Hagan covered the 8th versus when you went to the grand jury on the 18th. You remember that?
Yes, I remember him covering that.
Okay. Do you remember being asked by the police, how many shots do you think were fired? And you answered, oh, that gun has 6 bullets. So he had to fire every bullet in there. How many did you hear? 6, probably 6, about 6. You remember making those statements?
Yes.
Okay. And you remember, and in there, in those statements, the word 5 is never spoken, right?
Not in that particular statement, no.
Okay. So the word 5 is never spoken on October 8th, right?
Not in that particular statement, if that's on October 8th.
I understand you're qualifying your answer. But on October 8th,
Please.
I'm specifically asking you, on October 8th, when you testified yesterday with Mr. Hagan, that you had mentioned 5 shots, that in fact is not true, sir.
Judge. No, you may answer and explain your answer.
I'm going to explain again. If that's what it says on the 8th there, that I said 6 shots, then that's accurate if that's on the 8th.
Okay. Now, finally, sir, you mentioned yesterday, actually when you testified 2 days ago with Mr. Hagan about your activities inside the Cure Lounge, you never said at all, at any time, that you lost sight of Aaron Hernandez, right?
I don't recall saying that I did or didn't lose sight. I just recall saying we went to separate ends of the bar.
And you said that he was close enough to where I could see him.
Yes.
Okay. You never mentioned anything about a fan, right?
No, sir.
Now, yesterday when Mr. Hagan questioned you about this photograph with the fan, he says he showed you that photograph some time ago. Do you recall that question?
I believe I do recall him asking me that.
Okay. When he asked you some time ago, how long ago did he show you that photo?
I don't remember exactly.
Was it a year ago?
No, I don't believe it was a year ago. I mean, I don't remember
6
exactly.
months ago?
Again, for the second time, I don't remember exactly how long ago.
Okay. Did Mr. Hagan advise you when he showed you that picture that we just found that photo days ago and turned it over to the prosecutors?
Sustained in that form.
You saw this photo days ago, did you not?
I may have.
Now you remember.
I said I may have.
Okay, you may have.
Yes.
But a moment ago, you couldn't recall how long ago it was.
Right, which is the same answer. I don't recall how long ago it was. I may have saw it, but I don't know how long ago it was.
You do know the difference of being able to recall something days ago versus some time ago, like months, right?
No, you may answer the question.
Some time ago to me is just some time ago. I mean, I didn't say a year or however, at some point.
I know those weren't your words, they were his words. I know that. Well, my question to you is, you know the difference between days ago and some time ago, like months ago, right?
Are you distinguishing the difference between days and some time ago?
Yes, I'm asking you that. Can you distinguish that in your mind?
I mean, it may not be a huge difference to me in some time ago and days ago. Some time ago could be
But you don't recall
3 hours.
I'm sorry, I didn't.
Some time ago could be 3 hours. Some time ago could be 2 weeks.
But you don't have any recollection as to seeing that photo days ago.
Objection, asked and answered.
Well, sir, if you can, to your best memory, can you recall when it was that you were shown that photograph?
Not exactly, sir, but I do recall being shown the photo.
And that's because, as you testified, your memory gets better with time, right?
Yes, sustained.
Now, sir, finally, I want to ask you a couple more questions about this text. Right here, you say, after I tell the truth, the court the truth. Can you read that final part?
After I tell the court the truth about me not recalling anything about who shot me.
What are you saying to your lawyer in this text about what you're going to tell the truth about?
I can only explain the full context for you to understand.
No, I'm asking you a specific question. In this text, what are you telling your lawyer in a attorney-client privilege conversation what you're going to tell the truth about?
Sustained in that form.
What are you telling your lawyer that you're going to tell the truth about in this text message?
I'm telling my lawyer that I would be appearing at a grand jury.
No. I'm asking about what's in that text, sir.
He's not letting me answer.
You don't say anything about that. I want you to specifically tell me what you're referring to the truth about in that text message.
I'll see you at sidebar.
Sir, in the 17 years that you've been a drug dealer, how many forensic courses have you taken?
Objection.
Sustained.
Over the last 17 years, how many forensic courses have you taken?
Objection.
I have a basis for these questions.
Well, it's beyond the scope of redirect, but I will allow it.
That's the 17 years.
Well, I don't think the evidence is that the defendant was the witness was drug dealer 17 years.
It is.
It's 14 years, counsel.
We're in 2017, you testified 2000.
Till 2014.
Okay. In the last 14 years that you were dealing drugs, how many forensic courses did you take?
I've never taken a forensic course.
Have you taken any courses in digital forensics?
No.
Are you familiar with the Cellbrite software?
No, I'm not.
So you're not familiar with Cellbrite 1.5?
I don't believe so.
Okay. You're not familiar with any extraction tools that law enforcement would use, correct?
That is correct.
Okay. I'm showing you exhibit BBBB. This is the extraction report of your phone. Do you recall yesterday? I apologize. Do you recall yesterday testifying about how you voluntarily gave your phone up, right?
Yes.
And you signed a waiver?
Yes.
You were so forthcoming in that regard?
Objection.
Rephrase.
You were forthcoming in that regard, right?
Yes.
Okay. Now, in this extraction report, it basically how it breaks down your text messages. And do you see right here where it says DEL?
Yes, I do.
Okay. And here on this column are the deleted messages that you had on your phone. Do you see, sir?
I'll see you at sidebar.
Ditch. After you, which was in July 5th, 2013, prior to giving it to the police, you actually deleted that confidential message to your lawyer, did you not, sir?
Overruled.
I don't recall deleting that message.
Okay. Do you recall deleting all of these messages here?
Overruled.
I don't recall deleting any messages
Okay.
specifically.
Now, again, you've testified numerous times. You're in the drug trade, right?
Yes.
And part of the drug trade is not leaving evidence behind,
Objection.
Overruled.
right?
Depending.
And fair to say, in all the years you've been dealing drugs, you haven't spent a great deal of time in jail, have you, sir?
Objection.
Overruled.
That is correct.
Okay. Because you're smart.
Are you asking me if I'm
Yes,
smart?
you're smart, right?
I like to believe so.
Okay. And you know how to break the law.
Objection.
Sustained.
You know how to deal drugs without getting caught.
Objection. Ask the answer.
Let me answer that.
Are you asking me that?
Yes, I am.
I think that's fair.
And that's why you use burner phones. That's why you got two phones, right?
Correct.
One for the plug and one for the load.
What is that?
You don't know what the load is?
I'm trying to find out from you.
Okay. Well, if you don't know, that's all right. I'm the one that asks the questions here. So here we go, sir. You delete your phones and throw them out, right?
Objection to delete.
I take it it's delete.
Let me
content.
rephrase that. You, after 30 days, toss the phones, right?
Yes, my burner phone's not my iPhone.
Okay.
Which is,
And you have two phones at any given time.
yes, this is an iPhone, sir. Not a
Okay.
burner phone.
And when you burn these phones, after you're done with the burner phones, you don't renew and add minutes, right?
Not usually. I have in the past, I'm sure, but typically no.
Typically, no, because what you're trying to do is stay one step ahead of the law.
That's correct.
Okay. And that would include deleting messages on your phone too, right?
On my burner phone, yes.
Okay. Now, do you recall deleting any of these messages?
I don't recall any of the message I deleted. That's a long time ago.
Okay, wait. I gotta ask you. I want to ask you individually. These. How about these? You recall deleting any of these?
Objection. You just testified as in room with deleting any messages.
I didn't ask him about these, Judge.
Those calls or messages?
Why don't you establish what those are,
Okay.
Mr. Biles?
These are calls did you delete any of these calls too?
How can I delete my calls? Like, what do you mean? My call log? Is that what you're asking?
Yes, your call log.
I don't recall. I mean, I may have.
These are calls here from July 19, 2013. Excuse me, May 18th, all the way to July 19th. You see any of these that you might have deleted?
For the fourth time, I don't recall what calls or messages I may or may have not deleted.
How about any of these? You want to take a look at the dates and see if you recall?
No, overruled.
I believe I've answered the same question many times, Mr. Byers. I don't know what calls I have or have not deleted.
How about there? Do you recall that?
Again, the same response.
Okay. How about those? You delete those?
Same answer.
How about those? Do you delete those?
Same answer.
Those?
I don't know, Mr. Byers.
Okay. How about those?
I don't believe I know for any of these calls listed, Mr. Byers.
Okay. So out of any of these calls and text messages, you don't recall whether you deleted them or not, especially that one.
Not especially. I don't recall deleting any of them.
And the call again was to your lawyer, right?
I believe that looks like a text. Is that a text
I'm
or a
sorry,
call?
the text message.
Okay, the text, yes.
I have no further questions.